Welcome to the Federalist Society Faculty Conference and to the Young Legal Scholar paper presentations. I'm Stephen Sachs of Duke Law School, and it's my honor to moderate today's panel. Each year, the Federalist Society recognizes a group of young legal scholars, a group that to me grows younger every year, who have written unpublished papers of particular merit that year. I'm glad to welcome all of them today, and I look forward to discussing their papers. I want to begin by recognizing that it may seem odd for us in tumultuous times to be discussing complex legal issues, but in other ways, nothing could be more fitting. To paraphrase C.S. Lewis in Learning in Wartime, we're mistaken when we compare the present times with normal life. Life has never been normal. Even those periods which we think most tranquil turn out on closer inspection to be full of cries, alarms, difficulties, emergencies. Plausible reasons have never been lacking for putting off all merely cultural activities until some imminent danger has been averted or some crying injustice put right. But humanity long ago chose to neglect those plausible reasons. They wanted knowledge and beauty now and would not wait for the suitable moment that never came. In that spirit, let me introduce today's presenters. First to present will be Judd Campbell, Associate Professor of Law at the University of Richmond School of Law. Professor Campbell joined the Richmond Law faculty after serving as the executive director of the Stanford Constitutional Law Center. He holds degrees from the University of North Carolina at Chapel Hill and from the London School of Economics, where he studied as a Marshall Scholar. After completing his JD at Stanford Law School, he clerked for Judge Diane Sykes of the U.S. Court of Appeals for the Seventh Circuit and for Judge Jose Cabranes on the Court of Appeals for the Second Circuit. Next to present will be Katherine Mims Crocker, Assistant Professor of Law at William & Mary Law School. Professor Crocker joined the faculty of William & Mary from my stomping grounds at Duke, where she was an Olin Smith Fellow and postdoctoral associate, having practiced law at McGuire Woods LLP and having clerked for Judge J. Harvey Wilkinson III of the Fourth Circuit and for Justice Antonin Scalia. She received her JD from the University of Virginia and her undergraduate degree from Harvard University. Third on the list will be Jeffrey Hetzel, a law clerk to Judge Kevin Newsom of the 11th Circuit. Mr. Hetzel received his JD from Stanford Law School, where he was president of the Federalist Society Student Chapter, a Bradley Fellow at the Constitutional Law Center, and a Hoover Institution Rising Fellow. Before law school, he worked in criminal defense for 3 years, and he holds a BA from Middlebury College. At that point, we'll stop for commentary on the first 3 papers from Richard Epstein, who I hope is well known to all of us. He is the Lawrence Tisch Professor of Law and Director of the Classical Liberal Institute at New York University, the Peter and Kirsten Bedford Senior Fellow at the Hoover Institution, and the James Parker Hall Distinguished Service Professor Emeritus of Law and a Senior Lecturer at the University of Chicago. Professor Epstein has taught an extraordinary range of courses from admin law to workers' comp, with stops at contracts, property, torts, and Roman law along the way. His most recent monograph, following in a long line of prominent books and articles, is The Dubious Morality of Modern Administrative Law. We'll then take 15 minutes of audience Q&A on the first 3 papers, and I may pose some questions of my own. Afterwards, we'll have a second round of papers, comments, and questions. We'll start then with Sadie Blanchard, Associate Professor of Law at the University of Notre Dame Law School. Professor Blanchard was previously the Fellow in Private Law at Yale Law School, a Research Fellow at the Max Planck Institute on International Procedural Law in Luxembourg, and a law clerk to the Honorable Charles N. Brower of the Iran-United States Claims Tribunal in his capacity as an independent arbitrator in foreign direct investment disputes. She also practiced law in Paris in the International Arbitration Group of King and Spalding. Professor Blanchard holds an undergraduate degree from Louisiana State University and a JD from Yale Law School. Next to present will be Lorianne Updike Toler, an Olin Searle Fellow at Yale Law School. Ms. Updike Toler is a constitutional legal historian and was the president of Libertas Constitutional Consulting, where she specialized in best practices for constitution writing. She was the founding president of the Constitutional Sources Project in Washington, D.C., and helped bring about the Quill Project at Pembroke College, Oxford. She received her undergraduate degree and JD from Brigham Young University and a master's degree from the University of Oxford. After those 2 presentations, Professor Epstein will deliver another round of comments, and then we'll open it up for another round of audience Q&A. So thank you to the Federalist Society Faculty Division, to Professor Epstein, and to all of our presenters today. And with that, let's turn to Professor Campbell. Judd?
All right. Thanks so much, Steve. It's an honor to be on this panel, and thanks to the Federalist Society for organizing it and to Richard for commenting. My paper is about the emergence of viewpoint and content neutrality in speech doctrine. But I'm also trying to make a broader argument about how rights jurisprudence has changed, and particularly about how progressive jurists in the 20th century reworked and merged the earlier traditions of natural rights and common law rights. And so I'll begin by briefly framing the topic and then highlight a few aspects of the history. For the past 50 years or so, speech and press freedoms have largely been defined in terms of neutrality, essentially operating as non-discrimination rules. And this is true in two ways. First, the level of scrutiny depends typically on whether the government has targeted speech on the basis of its content. And then second, neutrality also prevents the government from justifying speech restrictions based on the harmfulness of certain ideas. So for instance, restrictions of hate speech can't be justified by an interest in preventing the spread of racism or other hateful ideologies, which of course sounds like an interest that's incredibly compelling. But they can't be restricted in that way because the interest preferences certain egalitarian views over hateful ones. And so what I'm trying to do in this paper is to trace when and how this neutrality-based view emerged. And my basic thesis is that it emerged later and more gradually than most scholars have thought, and that from a doctrinal standpoint, its emergence was interwoven with a broader transformation in rights jurisprudence. And in the remainder of my time, I'll focus on three facets of the history to show how neutrality was originally missing, both at the founding and in the early 20th century. And then I'll briefly describe how it began to emerge. So let's talk about the founding. And to begin, we need to recognize that there are actually two different traditions of fundamental rights that existed side by side. One was a tradition of what I've called fundamental positive rights. These were rights that tended to be derived from common law, the right to a jury trial, right to against ex post facto laws, and so on. And these rights usually limited governmental power in specific ways. And they also weren't defeasible in the face of countervailing governmental interests. So these were essentially rights as trumps. The other strand of rights jurisprudence was natural rights. But contrary to what most folks think of when they hear that term today, the predominant understanding for most of American history was that natural rights were regulable in promotion of the public good. And in fact, this is what later undergirded many of the police powers cases that the panel was discussing yesterday. And in this bimodal understanding of rights, common law rights and natural rights, this is what framed American rights jurisprudence generally, and then also speech and press freedoms in particular. In terms of common law rights, freedom of the press was generally understood as a ban on prior restraints, and the freedom of speech encompassed a privilege of speaking in good faith on matters of public concern, with juries applying that standard. But at the same time, expression is also an innate human capacity, and so it's easily identified as a natural right. And this meant that even if the government complied with the specific common law rules that I just mentioned, it still could only restrict expression when by law, and when doing so was in promotion of the public good. So the crucial thing to recognize here is all three of these facets of expressive freedom were in certain ways protective of different views, but not by imposing an obligation of neutrality that prevented the government from recognizing moral or socially defined boundaries on expression. Prior restraints simply meant that the government couldn't require you to get permission before publishing something. The privilege of speaking on matters of public concern wasn't defined in terms of whether the government had acted neutrally. And then outside of those two rules, the government could restrict speech whenever it was socially harmful. So none of these principles reflected neutrality, and this basic framework survived into the early 20th century, which is where I'd like to turn next. And I'll focus in particular on the doctrinal positions of Holmes and Brandeis in cases like Abrams, Gitlow, and Whitney. Today, we often read these opinions as explicating some general theory of expressive freedom, and that's sort of right, but in the paper I argue that Holmes and Brandeis were making a more limited type of argument, which was to explicate traditional common law principles in light of a more functional evolutionary approach to legal interpretation. This is the sort of approach championed by lots of other progressive jurists like Cardozo. And specifically, Holmes and Brandeis insisted that in order to punish speech, there needed to be a case-specific showing that the speech was unprivileged. Notably, that rule had nothing to do with neutrality. Rather, what Holmes and Brandeis were advocating here was essentially to adopt the distinction between prohibitions and regulations that the court used in vested rights cases. So a prohibition was a restriction of an entire category of activity, including non-harmful instances of that activity, whereas a regulation focused only on those instances that were harmful. So, for instance, a ban on all uses of alcohol would be a prohibition, whereas bans on drunk driving or public intoxication would be regulations. And if we apply that idea in the speech context, we see that it is perfectly okay for the government to target the dissemination of certain messages. There's no neutrality requirement. But Holmes and Brandeis insisted on requiring a case-specific showing of harm so that the rule operated as a regulation of speech rather than as a prohibition on the dissemination of certain ideas. Now, in the early 1940s, the New Deal justices embraced the Holmes and Brandeis view while also noting an exception for certain historically recognized categories of non-privileged speech. And here, of course, I'm referring to cases like Chaplinsky. Notice, though, that this idea of unprotected speech had nothing to do with content neutrality. There was no content neutrality rule. And in fact, doctrine at this point was actually hostile to the idea of neutrality. When a legislature passed laws that were facially speech neutral, like a ban on breaching the peace, courts had to carefully scrutinize the application of those laws to ensure that speech wasn't being restricted in a way that was privileged. But when a legislature determined that particular utterances were socially harmful, then that restriction came, quote, encased in the armor wrought by prior legislative deliberation, end quote, as the court put it in 1941. In other words, laws targeting certain messages initially received more judicial deference than speech-neutral laws. I'll conclude by briefly describing how things began to change. And once again, these developments were grounded on the more functional evolutionary approach to constitutional interpretation that was championed by the progressive jurists like Holmes, Brandeis, and Cardozo. For most of American history, we had these three different aspects of expressive freedom: the rule against prior restraints, the privilege of speaking in good faith on matters of public concern, and then this general public good requirement. And essentially what began to happen in the 1940s is that the boundaries of these categories started to change and the lines between the categories started to blur. So for instance, rather than just thinking about the rule against prior restraints as a ban on the licensing of publications, the court extended it to other situations where there was a similar risk of administrative suppression of disfavored speech: parade permits, solicitation permits, eventually movie licensing, and so on. And to figure out how to address these new doctrinal contexts, the court turned to a more functional account about the dangers of administrative suppression of disfavored ideas. Interestingly, the early champions of neutrality were actually the free speech balancers, people like Frankfurter and Jackson, who used content neutrality as a way of restricting the scope of the First Amendment. And it's really only in the 1960s, once Jackson and Frankfurter were gone, that the court embraced the idea that legislative restrictions of speech on the basis of content and viewpoint are especially problematic. So what began as a functional interpretation of traditional common law rules had by the 1960s turned into a more free-floating functional account of speech doctrine that was largely independent of those rules. Thanks.
Thank you very much. We'll now turn to Professor Katherine Mims Crocker.
Great. Thank you so much, Steve, and thank you, Judd, for your talk about your paper as well. So my article explores whether 42 USC section 1983, which provides a cause of action to sue state officials for constitutional violations, should be interpreted to make states themselves available as potential defendants as well. So the question is really whether you should be able to sue state governments rather than just individual state employees for infringing your constitutional rights under the law as it currently exists today. The Supreme Court has said that the answer is no. And my article argues that maybe the answer should be yes. So I'm going to outline the article's main arguments, and then hopefully I'll also have some time to sort of talk about how this piece fits into my work on so-called constitutional tort suits more broadly. So Section 1983 establishes a cause of action against every person who violates someone else's constitutional rights. The key word here is person. And the Supreme Court has said that person doesn't include a state because that interpretation just isn't obvious enough in light of background principles of federalism, including most importantly sovereign immunity, that make it unusual to hold states liable under federal law. The first substantive part of my paper puts this Supreme Court reasoning under a microscope. The principle that courts won't read statutes as abrogating sovereign immunity unless Congress is extraordinarily clear about that is an example of what the literature calls a clear statement rule. So I argue that it's inappropriate to apply a clear statement rule here to Section 1983, or to this particular clear statement rule to Section 1983 for two main reasons. So first, the Supreme Court didn't come up with this particular rule until the 1970s, but Congress passed Section 1983 in the 1870s. And at least in this abrogation context, the court never applies the clear statement rule with such an extreme degree of retroactivity. I think there's good reasons why it generally shouldn't apply clear statement rules in a retroactive way that I talk about in the paper as well. And then second, the court has implicitly justified applying the clear statement rule here by assuming that Congress thought about state sovereign immunity the same way in 1871 that the court thought about it a century later. But there's good reason to think that that wasn't the case. So Congress enacted Section 1983 at the height of Reconstruction after the Civil War, when the federal government was fundamentally transforming its relationship with the states. And before the court had decided the landmark case of Hans versus Louisiana in 1890, there was doubt about whether the 11th Amendment, which constitutionalized at least some aspects of state sovereign immunity, applied to suits against a citizen's own state in the first place. And presumably most Section 1983 cases will have always been suits against a citizen's own state. So the next substantive part of my paper drills down into the text of Section 1983 without the overlay of the Supreme Court's clear statement rule. I start out by asking what the word person generally meant in federal law when Congress enacted Section 1983 in 1871. So at the time, the so-called Dictionary Act, it was actually the very first iteration of the Dictionary Act, defined the word person to include bodies, politic, and corporate. And I walk through a lot of evidence that that phrase included states, and also talk about some counter arguments that it didn't include states. Then I discuss an amendment to the Dictionary Act that took place in 1874 that eliminated the bodies, politic, and corporate language. So as it turns out, it appears that that language was changed essentially by accident during the massive codification that Congress went through at that time. I think that this paper is the first paper to identify the definition of the word person as being one of the sort of accidental changes that happened at that time. But if anyone else knows of, another paper that makes that same claim, I would love to hear about it. So finally, I examined both the legislative history and the early litigation history of Section 1983. The gist of this section is that there's not a great deal of evidence that members of Congress specifically thought that Section 1983 would apply to states themselves, but that at least some members of the public apparently did because they tried to invoke the statute to litigate against states directly in federal court, to litigate against states directly in federal court shortly after the statute was enacted. So one thing that I've found sort of tricky in writing this paper is the frame of reference for methodological matters in statutory interpretation. Overall, I'm hopeful that the arguments and the evidence that I'm putting forward here will be potentially relevant to multiple interpretive approaches. But at the same time, of course, I recognize that different people will approach them differently based on how they think about statutory interpretation in general. Okay, so Switching over to sort of how this paper came about and how it fits into my work more generally. I previously wrote an article exploring the origins of qualified immunity, which you all probably know protects state officials from suits under Section 1983 and federal officials from suits under the somewhat analogous Bivens cause of action, when a plaintiff's legal theory wasn't a clear winner at the time of the challenged government conduct. So that article largely focused on how qualified immunity in part grew out of certain justices' separation of powers concerns in the Bivens context, given that Congress never approved of a cause of action against federal officials, and instead the Supreme Court just decided to allow them. But the more and more that I dug into qualified immunity and discussed my research with others, the more I became convinced that as a doctrinal matter, a critical part of the origin story for qualified immunity was that it responds to the harsh effects of sovereign immunity. And I also became convinced that as a practical matter, many or most of the sort of on the ground problems that people attribute to qualified immunity relate more fundamentally to a general lack of government rather than individual liability for constitutional claims. And that those problems could be improved by cutting back on the scope of sovereign immunity in the constitutional tort context. So what I mean by this is that on the doctrinal side, the reason the Supreme Court felt like it needed to create qualified immunity to protect the pocketbooks and the decision-making processes of government officials was because sovereign immunity meant that government employees and to a lesser extent, local government entities were left to bear the entire direct financial burden of unconstitutional conduct, even if government employers bore much of the practical blame. And then on the sort of practical side, cutting back on sovereign immunity would allow plaintiffs access to the deeper pockets of entity defendants and could put pressure on governments themselves to make top-down policy changes to address organizational sources of unconstitutional conduct. So when George Floyd was killed last summer and the response included a huge public pushback to qualified immunity, I wanted to come back to these issues, which eventually resulted in two separate papers. So the paper that I just outlined for you all today is the first part of this project. It's almost entirely backward-looking and formalist, examining whether previous Supreme Court opinions got things right in interpreting the words that Congress put into the statute books. There is a small sort of forward-looking part at the end of this paper, which basically tees up the next paper. So the second part of the project is far more future-oriented and functionalist. It basically argues that Congress should seriously consider reforming not only qualified immunity, but also how sovereign immunity applies in the constitutional tort context. So the point is that allowing more entity liability at all levels of government, and especially for excessive force claims, could help solve some of the problems associated with widespread indemnification and the tricky economics of unconstitutional acts. So that's where my research has been, where it's at now, and where it's going in the future in a nutshell. I welcome any comments, and I really look forward to your questions. Thank you so much.
Thank you. And now we'll turn to Mr. Jeffrey Hetzel.
Thank you, Professor Sachs, and thank you to everyone for putting this together. My paper makes one central point, and that will be the point I make in this talk. And that one point is that criminal juries in early America decided questions of law. So I will first explain what that means, second, describe what it looked like inside the courtroom, and third, answer a couple of likely follow-up questions. So first, what does it mean that criminal juries in early America decided questions of law? It means, rather simply, that juries decided for themselves what the statute under which the defendant was prosecuted meant, whether the prosecution was constitutional, whether any common law defenses applied, and any other questions of substantive law that arose during the course of the trial. All of these questions that today we think are the exclusive province of judges in early America were decided by juries. Second, what did jury power over matters of law actually look like? How did it manifest inside the courtroom? It manifested in two principal ways. Lawyers argued law to the jury, and judges told the jury of their power over matters of law. So lawyers routinely argued matters of law to juries in early America. In their opening and closing statements, they didn't just describe facts and remind jurors of the importance of their civic duties. Instead, they took out their copies of Blackstone's commentaries or Montesquieu or Vattel, and they read them aloud to the jury. They read passages from precedent, and they traced the history of statutory or constitutional provisions to their British origins, and they appealed to the internal logic of the law. Here are just three representative excerpts from the courtroom floor in early America. Number one, in the famous treason trial of Aaron Burr, the prosecutor, right in his opening statement, says the following to the jury, quote, "The question which presents itself to your view at this stage in the inquiry is, what shall constitute an overact of levying war against the United States?" Then for his broad definition of an overact of levying war, the prosecutor cited Blackstone's commentaries and Foster's Crown Law. And finally, he told the jury that the passage from the precedent that Burr was relying on was, quote, "a mere dictum that cannot be considered as an authority." Example number two, in an early state murder trial, the defendant was charged with murder for encouraging a man to commit suicide who eventually committed suicide. His defense lawyer said to the jury, quote, "Admitting the facts alleged against the prisoner to be in substance true, they do not constitute the offense by law denominated murder." He then read passages from 5 separate legal treatises to the jury and told them that despite, quote, "innumerable instances of suicide in Anglo-American history, the prosecutor could not cite a single precedent parallel to this in the history of criminal jurisprudence." And just one more example, in 1832, at a federal trial of a man who was accused of counterfeiting notes of the Bank of the United States, his defense lawyer said to the jury that Andrew Jackson's recent veto of the Bank of the United States on the grounds that it was unconstitutional represented, quote, "the true exposition of the Constitution." And so if the jury accepted Jackson's view, the defense lawyer reasoned, they couldn't punish his client for counterfeiting notes that were illegal in the first place. Nobody ever objected when lawyers made these legal arguments to the jury. Sometimes the legal arguments were the only issues at the entire trial, and lawyers argued them to the jury for hours or for days. The other principal way that jury power over matters of law manifested in the courtroom was that judges in their jury instructions point blank told juries that they had power over matters of law. Here are just a few representative one-liner quotes from early jury instructions. Quote, "The jury are not bound to conform to my opinion because they have a right in all cases to decide on the law and the facts." Quote, "The jury are to decide in all criminal cases both the law and the facts." Quote, "The jury in a general verdict must decide both law and fact." And quote, "The defendant rested her defense on a provision of the Constitution. Whether it applies is the, quote, great question involved in this case, which is about to be submitted to your consideration." An 1804 state court case illustrates just how important this power was to early Americans. In that case, a New York State trial judge instructed the jury that although juries could decide questions of law in all other cases, this was a libel case, and for some reason, libel presented an exception. The jury went on to convict the defendant under that instruction, and Alexander Hamilton took the case up on appeal. He told the New York Supreme Court that, quote, "Trial by jury never could have been a solid refuge and security unless the jury had the right to judge of the intent and the law." After Hamilton's argument, the trial judge actually claimed that he never gave the instruction in the first place, that it must have been mistranscribed. It was so unthinkable. And the New York Supreme Court upheld what it called the, quote, "right of the jury to determine the law as well as the fact." And if that wasn't enough, both chambers of the New York State legislature promptly passed a bill unanimously in both houses, declaring that in libel cases, quote, "the jury shall have a right to determine the law and the fact under the direction of the court in like manner as in other criminal cases." So all that shouldn't be enough evidence to convince you, but it's my best attempt at kind of a small representative sample of the evidence of early jury practice that I found. And third and finally, I'm just going to address two of the most common follow-up questions. One is, what happened to change this? What happened is that judges took the power away. Starting in the 1830s and culminating in an 1895 Supreme Court case, judges across America gradually began declaring that the jury could no longer decide questions of law. They prevented lawyers from arguing matters of law to the jury, and they instructed juries to follow their view on all matters of law. In response to this, many states passed statutes or constitutional amendments preventing the judges from usurping this power, but the judges brazenly read them out of existence. So Georgia passed a constitutional amendment guaranteeing that criminal juries, quote, shall be the judges of the law. The Georgia Supreme Court promptly read this constitutional amendment to mean, quote, it is the duty of the jury to receive and accept the law as given them in charge by the court. Basically 180 degrees from what the amendment says. The other common question is, what relationship did this history have with jury nullification? The answer is that this is not and never was a story about jury nullification. Judges made very clear to juries that they were not to decide questions of morality or conscience. They said, as Justice James Wilson said in jury instruction, quote, the jury in a general verdict must decide both law and fact, but this did not authorize them to decide it as they pleased. They were as much bound to decide by law as judges. Many scholars have misinterpreted all these references to jury power over matters of law as evidence of jury nullification. But as judges made clear in their jury instructions and as counsel made clear in the nature of the arguments they made to the jury, early American juries just did what we expect judges to do today, which is to decide the law, what the law means without deciding its morality. Thank you very much, and I'm looking forward to commentary.
Thank you. We will now turn to Richard Epstein for roughly 24 minutes of commentary, approximately 8 minutes per paper, but it's entirely up to you. Thank you, and Professor Epstein.
I'm a great believer in equity in these things. And first, I will make a general remark about these papers, which leaves me somewhat envious of them. The amount of careful, detailed historical research that has been done on these papers has been, I think, truly extraordinary. And even though in many cases I disagree with some of the conclusions, one of the signs of a good paper is that you can use material that is contained in the paper to ask your questions and to give your queries about what is going on. So I'm going to try to keep these things to equal time and to give sort of alternative explanations as to what's going on in at least some of them. The first paper is Judd Campbell's paper. And what he does is he starts to point out something which I think in principle is kind of correct, but somewhat misleading, namely that in the early kinds of cases, the questions that were associated with the judges were not treated in terms of viewpoint neutrality, content neutrality, and the like, but they had a much more substantive bite, which was associated with a then natural law tradition, which was often associated with, not in the free speech area especially, but more generally with the law and the tradition. One of the sentences that he quotes, for which I will not attribute to him, which I regard as one of the most dangerous statements in the history of Western civilization, mild hyperbole, is a remark from Justice Souter, which said it was the defining characteristic of the lock in the ear and its characteristic vice that the court treated common law background rules as the baseline for which a termination was going. I disagree with only one word in that sentence, not the word characteristic vice. I think it's the characteristic virtue of these particular rules. And what I want to explain is exactly why I think the transformation took place. And in order to do so, I'm going to start with a slightly more detailed substantive discussion of the kinds of cases that you can have. And it turns out that the reason the libertarian framework, which is disparaged by Justice Souter and to some extent gently put to rest by Professor Campbell, is, I think, appropriate, is in the early cases, they have the following kinds of characteristics. The start with the Patterson case dealing with bad tendency. We then get variations on the clear and present danger test, which run all the way through these cases, including the obvious tension that you have between Schenck on the one hand and Abrams on the other, going through Gitlow and so forth, until you get not quite to the end of this situation, but the frustration with this test in Dennis. And what's the issue that they're worrying about here? Well, this is a standard common law issue, which starts to say, what do we do with respect to assaults and batteries? And there are two states of the world in which you could look at. One of them is where the thing has already occurred, and the only question then is to fix damages for harms done. But going back to very early times, the single most difficult question in many cases was when it was that a threat of force would justify somebody to use force in response. And the common law case most closely associated with this is a case called Tuberville and Stamp, where it was assize time, i.e. the judges were in town, and somebody says, if it were not assize time, I would run you through with my sword, and the other fellow responded. And the question was whether or not this thing counted as a threat. And it's extremely ambiguous to figure out what is a threat, because sometimes you mean you're going to use force immediately, sometimes you're going to use it sometime in the distance. And so what you had to do with common law, and what you had to do when you start dealing with these various cases dealing with subversive behavior of the draft and so forth, is to figure out exactly when the harm is not concurred, when it is that the government can intervene in order to stop. It turns out that your common law baseline is one generally of free speech, but that common law baseline is subject to a common law exception that the threat of force against any other individual is actionable. And what you see is the Supreme Court in this whole line of cases is trying to figure out why and when various forms of anticipatory relief are going to be done. And the choices are bad. If it turns out that you intervene too quickly, what happens is you suppress legitimate speech. If you wait too long, the bombs are bursting in air. One of the reasons why we know that this is serious is that it gets further complicated by the law of conspiracy, which doesn't have associated with it any immediacy component. And as you look through these cases, I'll just mention a couple of things. One is that with the clear and present danger and the particular acts and so forth, there seems to be, at least in the mind of somebody like Holmes, a clear distinction that takes place between trying to urge people to leave a draft line Schenck as opposed to publishing Yiddish pamphlets. Then when you look at the situation in Whitney, it's important to remember that this enduring tribute to freedom of speech is in fact a concurrence, not a dissent from the conviction. And that what we do is we have a very well-established law of conspiracy with an overt act, which doesn't meet the clear and present danger test at all, and turns on a line of abstract advocacy. And then you get the utter frustration that you start to see in Dennis, where essentially you see the argument made that, well, if the putsch is not imminent, but it could be likely to be fatal, do we have to wait until it's too late in order to act? And so what we do is we get somebody upholding the Smith Act. There's no reason to think about the question of neutrality associated with these particular situations. So the reason it doesn't come up is that there's not the context. So when does the neutrality principle arrive? And I think this explains Judd's story without saying that it's a doctrinal transformation. It says you see this story because there's a change in the kinds of cases. Well, the first of the cases to deal with this is a dead loser. It's the case of Davis, in which it turns out that we say that the government is like the owner of private property. If it wants to keep people from speaking, it can do so. It doesn't have to give any explanation. But of course, the government is not like a private person. It is a trustee who has fiduciary duties to its various citizens. And this got expressed in the Hague case by saying, it turns out if from time immemorial, there was a kind of a public easement to use this. Now you've got trust obligations. And what's going to happen is, well, what the fiduciary duties do. If you're a trustee and you have only one person, the duty of loyalty is very easy. But if you turn out to be a trustee and you've got multiple persons that you have to deal with, then weighing and trading and balancing is going to become very important. So what happens in the free speech cases is as we start to move into the progressive era, we see a change in emphasis from the wartime cases to a situation where the issue is now, how do we decide who can get access to various kinds of public resources, or whether it's a public highway, whether it turns out to be a school and after hours and so forth. And these are all essentially cases of neutrality for perfectly good reasons. What you're worried about when you're dealing with a public trust is whether or not the government will use its powers to implicitly transfer wealth from one particular individual to another particular individual and to do so in a way which essentially is an illicit transfer. And that's exactly what brings up the stuff about content neutrality on the one hand, and viewpoint discrimination on the other. What you say, roughly speaking, are two loose presumptions. We'll have to worry about the exceptions on some other day. One of these two assumptions is that if there's an explicit preference, it's like a self-dealing situation, have a very strong, almost per se rule against it. But if it's a good faith effort to adjust, then you start to allow it. Then you have to figure out how you sequence. So in a case like Hurley, you run the common carrier, but you can't tell a private party what to do. If these were economic cases, then the ownership of the roads may well give you much greater power, so that the control of common spaces depends upon whether or not there's a level of strict scrutiny or not. First Amendment strict scrutiny, it carries over to common property cases. Economic regulations, Pache Lochner, it turns out it isn't that way, so you move in the other direction. So I think that Judd has the right historical arc, but I'm trying to give here an alternative explanation as to explain it. The second paper I'm supposed to look at is the one of Katherine Crocker. Again, this is extraordinary work, amount of detail and so forth that's going in there. So what I'm going to do is to start to look at this thing again as a kind of a common lawyer, to figure out the way in which these things start to work and the various kinds of rationales that you can start to bring with them. And as a common lawyer, what happens is you have to introduce, in order to find corporate responsibility, a particular notion which is not mentioned in her paper, nor in much of the litigation and disputes over the scope of Section 1983. And that notion, which does appear in some Title VII cases, is a notion of one of two things, and you have to decide which you want to use. One of them is a doctrine with respect to vicarious liability, and the other turns out to be a doctrine with respect to something like supervisory negligence. And in each of these two particular cases, what you're saying is you've got an individual who is the root cause of something that takes place. And then when that individual is insolvent, when that individual is beyond the scope of the jurisdiction, when that individual is nowhere to be found, what is going to happen is you're going to have to ask the question, is there somebody else whom you can start to grab and to put this in? And so the way in which I read the Section 1983 is I read person to mean natural person in the course of that particular statute. And I do so in part because if you start looking at the exception for judicial offices, it makes no sense in thinking about offices to think about them as corporate bodies. And the way in which I do it is to try to keep the two halves of this thing pretty much in sync, so as to have individual responsibility as the trigger for Section 1983. If you then start to look at the way in which this thing is going to work on these things, what they were really worried about is the dominant situation was unrestrained, essentially acts of violence and lawlessness by individuals who took the law into their own hand, the kind of things that later became the source of the Colfax massacres, the situation in Cruikshank and so forth. And so what's the proper way in which you start to deal with that? What you do to begin with is you start off with the individual theories, and then it ties back into what I said about Judd's paper, is that everybody understands that the criminal law will not be able to function if you could only respond to individual actions for particular events. And so we have other ancillary doctrines that come along, including doctrines about aiding and abetting, doctrines about attempts, doctrines about conspiracy, and so forth. And so the question when you start looking at Section 1983 is, does the existence of a particular statutory right tell us anything about the way in which we read these ancillary documents in pari materia or in coordination with the stuff that's going on here? And in my view, is the correct answer to that particular issue, which I think is the question answered generally with respect to all these statutes, is you put in the entitlement and you embed it into a larger Lochner-like common law framework, so that when you start to deal with these kinds of responsibilities, all these notions of vicarious liability go. These are not criminal statutes if you look at the kinds of sanctions here, but that really doesn't matter for these points because the collective responsibility through vicarious liability and oversight is in fact there, and you have to decide whether either or both of those two things are going to be appropriate. So that's the question about how you get other people in. Then there's the question, well, what do you do about governments that are involved? And here it seems to me that the Supreme Court, and I think Katherine's right about this, is very bad on the way in which it tries to deal with the issue of a government responsibility. Yeah. The first point that I would want to make is whether you're dealing with a local government on the one hand or with a state government on the other hand, you are not dealing with the kind of lawless activities that takes place outside the framework of a legal system. So it's always going to be much harder to find some kind of way to hold these people responsible, because you're going to have at least a weak presumption of legitimacy with respect to these kinds of actions, which you don't have to have, generally speaking, when you're dealing with disorganized or organized criminal activities of one form or another. So the question then is, if you're going to start to talk this about in terms of particular explicit, clear statement rules and so forth, I cannot see how you could come out with any distinction between the state immunity that was done in, I guess I can't even remember the name of the case, in Monroe, is that right? And then the exceptions that were done later on, so as to saying that we allow vicarious liability to apply to local governments. It seems to me that the distribution of functions that take place between the state and the local level is always going to be somewhat fluid. Sometimes you will have a state that will enact this stuff directly. In other cases, you will have a state that will enact this stuff under some kind of a situation. And when you start to see that there's going to be these sorts of variations, it seems to me to say that you want to have the same regime applied to both kinds of governments that you would want to have applied to each of them. There's no real reason to draw any functional distinction whatsoever. There's nothing in the statute that compels it or allows it. So then you have the question about, well, what about sovereign immunity? And here I think it's important to draw the following kind of contrast. There is no doubt that there is a huge tension between the existence of any kind of constitutional guarantee on the one hand and the existence of a doctrine of sovereign immunity on the other. The illustration that I worked about 35 years ago in the takings area is you say, nor shall private property be taken for public use without just compensation. And then we say the sovereign immunity doctrine means that you can get no compensation whatsoever because you can't sue the state. There's something very screwy about all of that. And one of the things that I was quite prepared to say in the takings book is that the takings clause in this sense would essentially be an implied repeal of sovereign immunity. And we never actually got to resolve that case because Congress then passed the Tucker Act, which essentially allowed you to go to the Court of Claims and to prosecute these cases. But now, if it's a question is state sovereign immunity, I don't think that this is something which is amenable to a fix at the federal level. So you have to go back again, I think, to the situation that you had in dealing with Chisholm against Georgia. And you look at that particular case, I always thought that the argument that the creation of diversity jurisdiction, or I would add any kind of federal jurisdiction, cannot be construed as a way to get rid of the doctrine of sovereign immunity, which was a bedrock position. And so I think I disagree with Katherine. I do not regard Hands as basically a kind of a tortured application of the 11th Amendment. I think the operative word in the 11th Amendment in many cases, which was adopted in 1798, before we had any judicial review at all, was the word construed, saying, look, this really doesn't mean what you guys had said. I don't think that it was the prohibition. I think it was a reinterpretation. And so the way in which I look at that particular case is to say that state sovereign immunity in a system of dual sovereignty is essentially something which cannot be abridged by the federal government. And so if you're talking in a pre-progressive era, same problem that we've talked about before, there is absolutely nothing that the federal government can do to tell the states that they have to waive their sovereign immunity. The only remedy you're going to have is to deal with the states themselves and to get them to pass something which most of them have done, a kind of mini federal Torts Claims Act allowing actions. And one of the things that you discover about both the state versions of this and the federal version of this is that people are enormously ungenerous when it comes to reading the scope of these things, so that a large portion of the Federal Torts Claims Act was gutted by two cases. Ferris with having to deal with military personnel, and then the Dalhide case having to deal with discretionary functions, both being read extremely broadly. And I think that's probably the way the situation is here. So my attitude about this particular situation is it doesn't depend on anything that the federal government wants to do. It's not a question, therefore, of something being part and parcel of a clear statement rule. It is rather a very different situation in which the sovereign immunity stuff tends to apply. The federal government is helpless to change it. It's quite clear when you start looking at the various transformations that takes place with 1937 Once we decide that you can subject federal governments to the Fair Labor Standards Act, we've changed the world. So what Katherine says applies there. Now, with 8 minutes to go, I'm still on schedule, and I want to deal with Jeffrey's paper and so forth. And again, I want to commend him for what I regard as historical overkill and impeccable research. I read these sort of quotations, and my first response to them is, "It's enough, please stop. You've persuaded me. You don't have to do it again, again, and again, and again." And of course he does it. And it turns out that I think he's probably right. One of the things that is extremely difficult for a non-historian who's interested in legal history to do is to figure out the timing of the transitions. But that's something that Jeffrey did, because I assume he knows all of the post-1835 cases, death of John Marshall's and so forth, and comes up with this particular situation. So the questions that I want to ask here are of a somewhat different nature. And the first of the questions is just exactly how important does it turn out that this particular change in the law has done? And my first instinct is, if in fact there is a change which is largely unnoticed, highly uncontroversial, and this thing does not seem to have provoked, maybe I'm wrong, but I didn't see anything in Jeffrey's paper, some kind of huge fights that took place, stirring declarations and so forth. It was rather a kind of a transformation. And so the question I wanted to ask is, one, why was it happen? And two, how important it was. So on the why does it happen, one of the things that sort of striking about the way in which this paper is drafted is that it does not give any explicit attention to what I would have regarded as the primary engine to trying to create lawyers rather than to do it. So the analogy I would start to give is to the discussion that Justice Holmes gives in the common law when he's talking about the question as to whether or not, when it comes to routine standards of care, we take these things from the jury and give them to the court. And what he says is, when a judge has seen a large number of cases, what happens is he could take cases from the jury because he is the repository of all that past wisdom. This new jury is likely to be mischievous. And so I can decide, for example, as to whether or not leaving an open grate on what looks to be a public sidewalk is or is not negligence per se. And there was then this huge fight over that particular situation as to whether or not you could take that from the jury. That's the kind of thing that's going on here. And I think that the competing interest that one has to worry about on these things is the real question about exactly why you want to make the shift. And the explanation that I think applies to so many constitutional doctrines is that things that work in the small republic don't work in the somewhat larger republic. I think there's an enormous importance in trying to deal with constitutional evolution to the size effect. So I've just written a paper on the non-delegation doctrine, and one of the conclusions you come up with is that back in 1789, Congress could do a lot of things by itself because there are relatively few members of both of these houses and so forth. But as the government gets bigger, it turns out that the ability to handle this in a deliberative body is completely inept, and that the need for uniformity across different cases becomes greater. And so the kind of working hypothesis, and Jeff could check it out or not, is with the judges getting upset because they thought that each of these juries deliberated in its own way. These were recurrent questions. And we have the Boston pothole case that our friend Oliver Wendell Holmes talks about, i.e. a lack of uniformity, which leads them to want to interfere. We also have another illustration of this, which didn't turn out so well, which is the whole sentencing guidelines, which is driven by exactly the same kind of stuff. And you get this very unhappy decision in Mistretta, which treats this thing as a permissible delegation. But what eventually takes place is that the effort to create uniformity seems to be defeated by particular circumstances. And I think Jeff, I hope, would agree with this to say that it's more likely to find uniformity in a jury if what you're trying to deal with is whether or not a criminal law allows the defense of self-defense or puts a burden of proof on somebody, than you are on trying to figure out which of an infinite number of circulations or circumstances could lead to a change in one way or another with respect to the way in which a particular individual ought to be sentenced. That is, liability questions, which he's talking about, tend to be on-off switches. You could get right answers or wrong answers or clear answers or not clear answers. But when you start to deal with the severity of sentencing, it's more like damages. And you could divide days into hours, hours into minutes, dollars into cents, cents into fractions of cents, and trying to figure out where on a continuum you put something is something which has generally been left to quote unquote the sound discretion of the jury or the trier of fact and equity. And I think that's probably what's going on. The second question that I want to ask, and I guess I have about 2 minutes to ask it, or 3 minutes, is the question of how much did this difference make? And my instinct about this is there are two kinds of cases. One of these are what you would call the kind of political case, the trial of Aaron Burr, the Zenger case with respect to freedom of chess, and so forth, where you can expect to see there's going to be hot passions. And it's not the question of nullification. What people are worried about in these particular cases, what you're always worried about, you get yourself a dominant prosecutor working for the government, and you're just afraid that if you've got the government on the prosecutorial side, on the police side, and on the adjudications, it's just too much. And that is essentially a lot of what Jeff says towards the end of his paper, right? The sort of the illusion of power. But then there are these ordinary negligence cases in which I don't think you have exactly those kinds of problems one way or another. And so you have to figure out which way you want to go with them. And so I think what happens is the routine case starts to dominate over the heroic case. And there the uniformity issue turns out to be somewhat stronger. It turns out the ability for you in these particular cases to implement a system of uniformity is going to be somewhat great. And then the question is how many changes in the outcome are going to be. And there were two things that Jeff mentioned that he in his paper, which he didn't put in here, which I think influenced this in a very powerful way. One of them is the judges get the right to determine what is or is not admissible evidence. And this is surely going to change the way in which these things are done. And secondly, it seems to me, as I recall the paper, that any determination on law that's made by a jury is subject to review by an appellate court in the same way as if it would be made by a judge. And so what happens is you get those two constraints in addition to the third restraint, which is you guys are here to do one thing, get it right. Your job is not here to interpose yourself between. So how strong is the risk of jury nullification? Well, the answer is it's very strong. But you can have jury nullification even if you have the law decided by the judges. Juries can just walk on the facts, and there's still the case that there's no way in which you can stop them. And in fact, where the jury nullification issue is very serious, and I'll just end on this note, what you do is you see a change in transformation. So to mention two cases to you, Jones and Laughlin and the National Labor Relations Board, there's a Seventh Amendment challenge because they take these determinations out from a jury and they give them to a bench. Then under the Civil Rights Act of 1964, these are also not jury cases because they're worried about what Southern judges are going to do. And so I think, in fact, where you do see the nullification issue, and it's regarded as important, sometimes you instruct juries, but institutionally, you don't always do that. So the end of this particular story is, I think this is less important, which explains why it went relatively unnoticed. I am now done on time. Thank you.
Thank you very much. Very well timed. And I'm actually going to depart from the time schedule to give 30 seconds, if they want it, to each of the presenters in order, if they have any comments on the comments before we open it up to audience Q&A. So Judd, any thoughts?
Sure. So thanks so much, Richard. That's very helpful. I think Richard's exactly right that we see neutrality emerge in part because a new type of case is emerging. Some of those are the public forum cases. Notably, the early neutrality principle in public forum cases is limited to administrative discretion rather than legislative discretion. In this particular, a lot of pressure on the doctrine is coming also from cases involving communist exclusions of various sorts in the 50s. I think that's exactly right. I do want to emphasize, though, that it's not that there was a neutrality principle that was sort of latent but not exposed. In fact, if we carefully examine the early frameworks, they were actually hostile to the idea of neutrality. They forced the government to address specific harms, and that's not a neutrality-centered way of thinking about the nature of the problem.
Katherine, any further comments?
Sure. Richard, thank you so much for your close read of the paper and your really insightful comments. I obviously couldn't respond to all of them in an efficient way here, but I'll just make a few points. I do think that there's some good historical work that other people have done on sort of Congress's understanding of vicarious liability in 1871 and how having vicarious liability in Section 1983 might have, broadly matched up with the way that Congress saw that doctrine. So I think that you make a really good point that I should try to explore that at least somewhat in this paper. And then some of your sort of points towards the end. I mean, this paper has really, it's sort of, in the one sense, it sort of zooms in on abrogation of sovereign immunity, but it's given me an opportunity to think about sovereign immunity much more broadly. I think I'm sort of leaning towards Steve's understanding of the 11th Amendment and sovereign immunity, which I think does allow for abrogation and sort of reads Hans in a way that is, I think historically accurate in terms of Hans itself. It doesn't reject Hans, but it reads Hans in a different way than sort of than the way that the Supreme Court has read Hans more recently. And I should give credit to both Steve and Will Bode, because it's a view that they've both promulgated in several recent works.
Thank you. And Jeff, any thoughts?
Thank you. And thank you so much, Professor Epstein. That was awesome. I'll just try to briefly address that first question of kind of why did this happen by saying how we're speaking past each other a little bit. I think that that's a really interesting question, but in my paper, I was just trying to figure out what the law requires. And I don't think that judges can willfully change the law for any reason. And that's especially true in the case of the allocation of powers within the criminal jury, which is almost certainly guaranteed by Article 3 in the Sixth Amendment. And so there are a lot of different theories of why the change happened. Actually, Professor Campbell emailed me about several more interesting and fascinating ones. And I feel like that's a different paper. It's a really interesting and important paper, but it shouldn't affect what our law requires today.
Mm-hmm. Thanks to all. We will now open up the floor for audience Q&A. If you would like, you may put yourself on the queue using the raise hand function in Zoom, or if you're dialing in, you can use, I believe it's *9. And if folks have questions, just raise their hands and I will name you, and then the wizards behind the scenes will cause your photo to come up and your video to come up, and you should unmute yourself. So we'll start with Lyle Weinberger.
Lyle.
Great. Hi, can you hear me?
Yes.
Great. So, boy, these were great presentations. And I've got multiple questions, but I'll limit myself to just one. And I wanted to ask Judd if he could comment on what he thinks might be going on with the rise of neutrality, something that I think Judd pointed to as he answered Richard's comments a little bit, was that neutrality was not something that was implicit there already. It was something that is actually a new development. And I wonder if you can comment on why neutrality and why then. To me, so just to put one idea out there, I wonder if this relates to actually changing ideas about the state itself and the appropriateness of the state in taking substantive positions on the nature of the good life and things like that that we commonly think of as implicated with natural rights traditions, for instance. And is this really another window into an emergence of a more neutral, liberal state in a kind of Rawlsian or proto-Rawlsian sense? Is this what we're seeing here? Or is something else going on in terms of the intellectual currents that are driving the rise of neutrality?
Yeah, that's a great question. So the paper itself is just focusing on the doctrinal transitions. I'm not trying to ask or answer questions about causation, but I think what you're pointing to is surely right. A related point here is a decline in the notion that there is such a thing as a substantive common good that we can refer to, and particularly in reference to judicial determinations of what that substantive common good are. I think another aspect of this is the judge's efforts in the 1960s in particular to try to respond to problems of racial discrimination in a way that made them seem neutral. And so they addressed a lot of problems that are actually fundamentally race problems, problems of systemic white supremacy in southern states and hostility towards Brown, by treating them as speech problems. And a neutrality framework in speech jurisprudence was a way for them to try to combat substantively some of the racist problems that they were confronting, without having to just call a bunch of southern states racist, which is essentially what they were.
Just one comment. I think, in effect, when you're dealing with defamation and assault cases, you better be very Viewpoint sensitive. We're not indifferent to somebody who wants to kill somebody as opposed to somebody who says, I'd like to persuade you. So I think, in effect, that even today under modern doctrine, the neutrality principle applies to the allocation of public forums and so forth. And on that, it turns out if you're dealing with economic stuff, we have this huge belief in the common good that we could run through zoning regulations and so forth. The moment you try to do that on speech, the preferred freedoms doctrine starts to come in, and we're deeply suspicious about that, and we sort of allow everybody to speak their own way. So I think it's the level of scrutiny is high. The neutrality principle bites. When the level of scrutiny is low, I think it does nothing.
Thank you very much. Next question is Lee Otis.
Thank you, Steve. This is a question for Jeff, actually. I was wondering if you can tell us a little bit about what appellate review looked like for these jury determinations of law.
That's a great question. So my impression, my takeaway from the evidence was that the most important thing is that, and this is kind of obvious, but it takes some getting used to, is that if the jury acquits for a reason of law, there's obviously no appellate review. So the jury acquits based on a reason of law, and that's the end of the case. Just like if they acquit based on reasons of fact, that's the end of the case, even if they're, totally unreasonable about those reasons of fact. If they convict based on their judgment on a question of law, the first level of review is actually the trial judge, who can say, this was totally unreasonable to the extent that I can isolate the question of law from the question of fact. This was a totally unreasonable judgment on a question of law, or there is no reasonable combination of law and fact on which you could get to a conviction. And so the trial judge can then overturn on that basis if the jury convicts, and then the appellate court can basically just review what the trial court did. The effect of this is that acquittals get no review, and review of determinations on matters of law in general is much more limited, because you can't look in and see the legal reasoning. You can just say, kind of as a whole, was there a reasonable way to get to this outcome?
Yeah, look, one comment on this is the general issues of jury control, I think, were very ill-defined through about 1835 or even a little bit later. And when you put the torts books out there and so forth, you're trying to figure out what's going on. A lot of the oversight starts to come in the last half of the 19th century rather than beforehand. And again, it's the same question about, we believe in juries know stuff, but we're worried about extraordinary cases and abuses. And so we do have juries notwithstanding the judgments, notwithstanding the verdicts, rejected verdicts, and so forth. And so I guess the question I would ask for Jeff coming off of this is, do you know exactly how these other jury control methods like instructions operated in the 1835 and before period as opposed to afterwards? Is there any change in that, or is it pretty much constant all the way through?
Did you say like instructions?
Yeah, I mean, one of the ways you limit what a jury can do is you instruct them on the law, right? Well, can you do instructions in the pre-1835 statement, or is that categorically banned?
Great question. So what would happen in a lot of these cases, and basically all of them that I read, is the judge would say, after you've heard from both lawyers about what they think the law is, here's what I think the law is. And they would explain why. And they would even say sometimes, like, And listen, like, I'm a judge, I'm pretty good at this stuff. Like, it might be smart to defer to me. But then they would conclude those jury instructions by saying, as I read in the quotes to you, but no matter what I say, ultimately it's your decision because you have power over matters of law.
I see no questions. Can I ask a question then? If
Sure, go ahead. I was going to jump in.
I wanted to ask, this is a question to Katherine about her particular paper, which is, let's suppose that we're in the modern soup, which is that sovereign immunity as an absolute barrier against federal alteration of 1983 is gone. Exactly what do you want to do and why? People mention the Floyd case, and I think that there's just a huge amount of misunderstanding about that case, depending on whether you saw the full 30-minute film or only the 8 minutes and 48 seconds where somebody's sitting on this man's head. And so exactly, A, do you want single cases like this to determine major law reforms? And B, exactly what do you think is the appropriate situation? Remember, this was the St. Paul preach, their local government is liable, you want to go after the state. I'm not at all sure, once you basically have knocked down, if you have done this, the sovereign immunity is an absolute defense, where it is you go in this second iteration. I realize this may be paper number 2, but I think it's important enough to ask it at the time of paper number 1.
Yeah, thank you. I appreciate that question. And this is paper number 2, but I'm happy to talk about paper number 2 now. They used to all be, I used to have just one big paper, but it was sort of too big to try to tackle all of these issues in one paper. So now it's 2 papers. I think you and I might disagree about the George Floyd case and whether that's representative of, problems more broadly within law enforcement. But what I'm proposing is basically to expand entity liability, at all levels of government. So to expand it at the local level where it already exists, to allow it at the state and federal level. In terms of the substantive standard, to basically look at a common law respondeat superior standard, in part because that really helps match up, basically the doctrine with the reality, because the reality on the ground right now, according to, a lot of good recent empirical scholarship, is that governments are actually paying constitutional tort judgments and, indemnifying litigation expenses, essentially in any case that happens within the scope of employment.
Can I ask one question?
You raising your hand, so yes.
One question about that. Suppose under the current system where you have to get the guy liable and then you get an indemnity, do you think the judgments would be of the same size if everybody knew that the state was required, as opposed to a situation where you know that they're likely to reimburse but may not reimburse if in fact you go over the top? So the question is not just whether or not it's 2 steps or 1. The question is, will the size of the verdicts be the same in both contexts?
I think it's possible that the verdicts will be larger if, everybody knows that the government's pocketbook is essentially on the line. I don't think that's necessarily a bad thing. But I do think that, yes, I see you. I know there's definitely,
the shame.
Yes, but I was just going to say also that so Joanna Schwartz in particular from UCLA has done some good research showing that, these judgments, even if they were sort of a bit larger than they currently are, and she's talking about removing qualified immunity, which I would also support, but that it's not like they're likely to bankrupt, especially state and federal governments. Even on the local level, most local governments now have access to insurance, or the large local governments are self-insuring in such a way that this is only constituting like a small percentage of their budgets. And so that's one thing that I try to talk about in my second paper, that I don't think the sky would sort of fall if we opened up governments to direct liability.
Do you remember the reaction to, 1 second, to DeShaney? All the social work groups were absolutely apoplectic about the thought of any liability, even for reckless misconduct. They said you could bankrupt us, and we're shoestring budgets all the way. So I don't think you should think about this only as a police department. There are other agencies that are involved. But Steve, I think time is up, isn't it?
Yes, it is. So we will turn to our next set of panelists, and first to Professor Sadie Blanchard.
Thank you, Stephen, and thanks to the Federalist Society for hosting this, Professor Epstein for commenting, and for all of the participants for being here. Several colorful case studies have shown how small, tight-knit communities back commitments among themselves using reputation. Many of you are probably familiar with Lisa Bernstein's work on New York diamond merchants and Bob Ellickson's work on ranchers that govern their relationships without relying on the legal system. Many scholars have assumed that reputation-backed commitments like this can work only under these kinds of quaint conditions where there are ethnic ties or it's kind of a small community dynamic. Today, I want to talk to you about a case study I did of the global reinsurance industry, which used reputational governance under very different conditions. Reinsurance is insurance for insurers. So reinsurance firms and the primary insurers that they trade with, they have to trust each other. The primary insurer has to be able to rely on the reinsurer to pay claims when they come due as promised. And the reinsurer has to be able to trust the primary insurer to be prudent and to be honest about what risks it underwrites and not to pass off bad risks to the reinsurer or not to properly scrutinize claims before paying. These businesses managed to grow. They grew their industry and to sustain the worldwide insurance industry for many decades without relying substantially on the legal system. So this is an example of a group that relied on reputation even though they started with no ties to one another. To understand how they did this, I dove into the trade literature and I interviewed people who worked in this industry during the time that it operated on the basis of reputation. And this case study shows some of the ways that reputation can be used to sustain trade beyond the small town or the clan scenario. Before I get into the things that I found in the reinsurance industry, I want to say a few words about why anybody should care about this. If you're not an anarcho-capitalist, which I imagine there might be a few in the audience here, but most of us probably are not. So should the rest of us care about this? So the reason that these groups are interesting is that they're extreme versions of a more general phenomenon. There are many potentially value-creating deals that can't be supported entirely by judicially backed contracting. So here's an example. Imagine two firms that want to work together to develop a new product that meets certain performance standards. Collaborations like this between firms have become a key source of innovation in the economy and new technology. So you have a situation where each firm has expertise in some aspects of the product design or the production. They know what they're trying to achieve, but at the beginning, there's a lot of uncertainty about how they're going to do it. They're not exactly sure of the boundaries of what each side is undertaking to do. But what they want to do is commit to each other to each invest substantial resources and effort and share knowledge with each other, working toward this vision of a certain product that will perform in a particular way. But if each party is concerned that the other is going to shirk and free ride on its effort or steal its information, the collaboration might never happen, or you might have underinvestment, which is likely to lead to a failure. But because the uncertainty is so great about what they're going to do or how they're going to do it, they can't define their obligations in a way that's easy for a court to verify. Like they're not saying, I promise to produce 1,000 widgets by June 1st, and I promise to pay. It's something more vague than that. So they could try to set out standards like put forth best efforts. But what are best efforts? How is a court going to know what that means, especially if this is an undertaking that's kind of novel and innovative? How can a court tell whether somebody has put forth their best efforts? It's going to be expensive for a court to figure that out. It might even be impossible for courts to get it right. So these kinds of limits of courts and of contracts, we see them all around the economy, okay? So by looking at groups that have succeeded without legally backed contracting, we can learn about alternative ways to sustain trade. when courts are not able to do the job. Okay, so it's not about saying everyone should stop using contracts and stop going to court. It's when courts are not able to do this, what else can be done? And understanding this can help lawyers better advise their clients on how to design transactions. So what this case study of reinsurance gets at really is, what are some of the techniques that can sustain cooperation when formal law is a bad fit? There's a lot of detail in the paper about how this was done, and I don't have time today to get into all of it. So I'll say that the key takeaway is that diamond merchants and McGreevy traders turn out to have been special cases of a more general phenomenon, which is governance by reputation in a social network. And what I argue that this case study shows is that when potential gains are large enough, it's possible for a group to build a network that will serve as a conduit that allows them to share information about behavior, to establish trust, and therefore to trade with each other. They don't have to have been a clan from the beginning to be able to do this. And I'll talk about 3 of the mechanisms that were used in reinsurance to pull this off. Okay, so the first thing they had to do was get cooperation on the ground, off the ground, right? So they're starting from zero. How do you get it started before you have a network in place? They did that by designing contracts that closely aligned the parties' incentives and committed to radical transparency. I'll say more about that in a minute. The second thing they did was to create convening points that allowed information to flow between groups that might have been sort of clustered or tightly connected within themselves, but there would be a different cluster somewhere else, and there weren't a lot of ties between those groups. So convening points to bring people from different clusters together. And the third thing that was important was making targeted investments in personal relationships, again, primarily to bridge these clusters of closely connected groups. So I'll say a little more about each of those. So the first one, I said getting trade off the ground by designing agreements in a certain way. Incentive alignment was about making sure that if the reinsurer lost big, it would inflict pain on the primary insurer as well. So the key way that they did this was by something called the retention requirement. So the primary insurer was required to keep on its books a certain percentage of every risk that the reinsurer took on. The primary insurer also had to be ready to open its books to auditing at any time. Okay, so this was the transparency point. This allowed a relationship to get off the ground. Once the relationship was formed, it gave the parties an opportunity to start learning more about each other. How competent were they? How trustworthy was the other side? Then they could make more valuable deals. They could price more optimally. They could do bigger deals, riskier deals, and they could do a greater variety of deals because they didn't have to do this strict incentive alignment anymore once they knew more about each other. In addition to allowing more valuable trade between the two, this was the beginning of a building out of a network. Now they could share connections that each one had respectively with each other. They could vouch for one another, and they started building out the network in this way. I will not say much about the convening points because we're very low on time, but these were international meetings, basically, is the upshot of it, that brought people together from Europe, primarily at the beginning, Europe and North America, but that spread to other continents as well, everybody coming together from all around the world to meet in Europe and talk a lot and gossip a lot. And the third is this personal investment in key relationships. And so this was traders cultivating close personal relationships with selected counterparties. Okay, you couldn't do it with everybody, but you could choose certain strategic relationships to develop. And business for these people became a family affair. So the firms would pay for their executives to bring their wives on business trips. It was always wives at the time, given the era. And they would encourage their families to get to know each other, become friends. They would take vacations together. This lowered the cost of getting information about the quality of the friend's business. It also enabled these higher stakes deals that I mentioned before. And it also, again, it created the opportunity to share trusted information about people very far away. So you had one key relationship with somebody in a distant market, and you could trust that person to tell you the truth about other people in that person's cluster. And I'll stop there. Thank you so much, and I'm looking forward to your comments.
Thank you very much. And now to Lorianne Updike Toler.
Thank you so much. It's a great privilege to be participating in this group and to hear so many historical papers. My history deals with how the Supreme Court deals with history. And I'll start off with Justice Gorsuch's decision in Bostock from last summer, which sent shockwaves throughout the legal field, particularly because he, of course, used textualism to interpret Title VII in extending anti-discrimination bans for the homosexual and transgender community. Now, regardless of whether textualism was pretext for Gorsuch's, what the minority called humane and generous impulses or not, if we scale back a little bit and look at this at a higher level of generality, political deviations from expected results should be expected when one puts methodology over politics, when one truly follows a method, which Justice Gorsuch claimed to do. My paper, Law Office Originalism, looks at whether method is chosen over politics in a different context, which is in originalism, or more broadly, using history in constitutional interpretation at the Supreme Court level. The epithet of law office history was used to critique the Warren Court's use of history as a judicial tool of change, and was renewed to critique originalism's claim that history could be a means of judicial restraint. Law office history is understood as bad history, or where individuals, judges, and advocates cherry pick historical quotes and vignettes, wrenching them from their context and using them to legitimate political outcomes. My paper is the first to test the claims of law office history with 3 hypotheses. The first is that the court's historical methodology is generally bad. Number 2, that originalist justices' historical methodology is no better. And 3, finally, which is the crux of the argument, that engagement in better historical methodology will result in significant political deviations. To test these hypotheses, the Law Office Originalism study looked at both descriptive and inferential statistics using the universe of all 299 of the Supreme Court's references to the Constitutional Convention records. These hypotheses will be addressed in turn as I proceed, and then I'll talk about the significance. So the first hypothesis, which is that the court's historical methodology is generally bad, was confirmed. Here, we mostly use descriptive statistics with a couple of inferential statistics in terms of Fisher square or Fisher exact tests. And the rubric in which we tested good historical methodology was based on the premise that good historical methodology is based off of accurate facts and contextualization. In terms of testing it, this we thought could be expanded to or tested by looking at the appropriate and use of the right primary and secondary sources. So we therefore tested whether, when a reference was made to the Constitutional Convention, there was a citation at all. Surprisingly, there were references to the Constitutional Convention where there were no citations, which I'll go into in shortly. And whether and what primary and secondary citations were made, as well as the overlap between primary and secondary sources, with the gold star being using both the right primary and secondary sources in an overlapping fashion. We also ran Fisher exact tests to see if certain events, like the professionalization of history, The rise of the Warren Court, which we'll see, was significant, as well as the making sources more available made an impact on their use. And I will now turn to some of these statistics. So here, here in the first slide, we see that we see the court over time marked by the different chiefs in the bottom. And this is, the end of it is not 2005, but rather 2019, when we stopped looking at different justices' opinions. And this is based off opinions, not necessarily majority decisions. So all concurrences, dissents, and majority opinions. We see the orange is reference without citation, and the blue is reference with citation. So we can see a huge rise in the use of citations with the Warren Court that then tapers off. This is actually significant. The other significant date that we found was that 1996, when the records were made available online, as well as 2006, when they were made searchable on ConSource, actually correlated with a decrease in primary sources, and we'll talk about that with citations. References and citations, as we see here in the next slide, are different. References refer to when the convention was actually referenced, whereas a citation is an actual cite to a specific source. So you can have one reference with multiple citations. Often we see in the Supreme Court now string cites. This reflects that. So the green is secondary, and there's no great way to demonstrate this, but the secondary sources and the overlap with primary citations is shown here in the green, lighter area and darker, and then primary is shown in yellow with the corresponding primary and secondary overlap down below. Now again, we have tracked and quantified things that are traditionally not quantified, and so it's hard to put this all in one graph because this reflects 563 primary and secondary citations from 299 references. And when you have a secondary cite, you can often, and generally there were multiple secondary citations for every primary cite, but there's also, as you can see, and it's a little bit small down here, but you can have secondary citations without any overlap, meaning there's no primary citation whatsoever. So going back really, really briefly, we see that in this first slide that there are references without citation. The good news here is that these are going down. They've gone down to 0 with the Roberts Court. This is your traditional armchair historian ship, where you're not citing to anything at all. You're just referencing the Constitutional Convention. Sometimes this is appropriate, such as when they're making reference to the convention in passing, or it's a biographical reference. But generally you want a citation. This happened roughly 18% of the time. And again, it's gone down to 0, so that's good news. When you look at secondary citations, the problem here really is that you have a low reference to primary citations. There's many, many more. The court is largely relying on secondary citations. And as you look at the primary citation graph here, there's very low overlap with secondary citations. So you have, when you do reference primary sources, it's frequent not to reference a secondary source. So those are some of the problems there. And just to give you kind of a feel for this, nearly half of all references to the convention have no primary citation, or 45% overall. And that's thankfully gone down with the Roberts Court, which shows signs of progress, that 27% of citations to the Constitutional Convention by the Roberts Courts have no primary citation, or 27 of the references. We've talked about how putting things online actually correlated with a decrease in citations to the convention. That might have other explanations, such as the de-emphasis of the convention within the rubric of originalism. but it's troubling nonetheless. There's also a greater need for overlap. As I mentioned, it's quite problematic that there's lower overlap for primary citations. Next, we'll look at, with the court's over-reliance on secondary citations and often to the exclusion of primary citations, we want to look at, are they looking at the right sources? And you can see here the largest section here are previous cases. We quantified a secondary source as anything that wasn't the Constitutional Convention. So you have here other historical sources like the Federalist Papers, like letters and journals, etc. As it relates to the Constitutional Convention, those can and were quantified as secondary citations. But if you put together the previous case and statutes, you approach something like 50% of all secondary citations are to cases, leaving only 12% and 15% of books and articles as references there. And then if you look more deeply into these, none of the articles are actually historical articles. None of them are published in historical journals. And of the books, there's 43 books which are referenced, and only 32 of those, of those are written by lawyers. Of the 9 written by historians, only 2 were major works of history by Charles Beard and George Bancroft. Okay, let's now, for just a moment, I wanted to focus, oh, I'm so sorry, it looks like I'm out of time and I haven't gotten to the most important slide, which if I might be permitted, I'm going to share now. Okay, and that is that we can look here at our regression analysis. And to explain this really briefly, the blue coefficients represent, there's 8 different justices here, 6 of whom have jurisprudential commitments, 3 non-originalists and 3 originalists, Black, who's a proto-originalist, Scalia, and Thomas. And then we have Warren and Stevens as the index justices, as atheoretical justices. The bolded are represent significant values, and we can see the blue coefficients demonstrate that all of these justices are less likely to use primary sources, including the 3 originalist justices, and Black significantly so, than all other justices since 1935 in using primary sources when referencing the convention. And then, so originalists are not better historians than non-originalists. And then the orange bars demonstrate the interactive variable of political deviation. And it shows us that there is a trend that when you use primary sources, you are more likely to deviate politically from expected political outcomes using the Siegel Cover Supreme Court database. And if you have no jurisprudential commitments, such as Warren and Justice Stevens, you are significantly more likely to deviate politically. We see a trend here, and unfortunately, Thomas, there is absolutely no deviation from his politically predetermined outcomes. So with that, I will pause and yield my time. I apologize for going over.
Thank you. We'll now turn back to Richard Epstein for comments on both papers.
Yeah, I mean, these papers are highly heterogeneous relative to each other. And so I don't think it's going to be as easy to link them together. These are both areas in which I've worked at some point in time. And so let me start with the first paper. Sadie, it turns out I was the editor of the paper that Lisa Bernstein wrote with respect to the Diamonds paper. And I mean, it was the most extraordinary thing you ever read. I looked at this thing, which was 3 times as long when I got it as it was published. I said, this woman must be in the diamond industry from the day she was born. But no, she had done this as a research paper at Harvard under the supervision of Steve Chabelle, and did ask the question about how it is that we start to keep these groups together in one form or another. And what you do is you basically divide the analysis into 2 parts. One of them is a sort of a generalized commitment as to how these relationships work. And then the second one is the question of how it is that these things manifest themselves in the reinsurance kind of context. And let's start with the particulars and go out. One of the things I would say about this is reinsurance is not the only kind of situation where you have to worry about the question of good faith commitment with respect to these situations. What's interesting about the reinsurance companies, and correct me if I'm wrong, is if you look at the major ones like Swiss Re and Munich Re and so forth, they are reinsurance companies. That is, they highly specialize in this kind of stuff. There are generalized insurance companies like Aetna and so forth, which may do some kind of reinsurance lines. I think it's important to understand what the difference is, because if you're in the reinsurance line of business, then not only you don't have the advantage that you get behind the veil of ignorance of developing a set of rules which will help you and hurt you depending upon whether you're the ceding or the company to whom the losses have been ceded, you're always going to be in that position. And so the trust relationships are going to have to be very, very high given the size of the commitment, which I think is exactly what you've done. One of the things I think that you might have wanted to add to this discussion is that this is often a two-stage process. That is, when you put these contracts together, what happens is you have to worry about the ways in which these losses are going to go and how much. And it's extremely difficult to make the kind of estimation because you're doing the worst of all estimates. You're trying to figure out what's going to be a very big number of loss associated with a very small probability. And when you try to multiply those two numbers together, the variance is much greater than if you have a modest loss and a higher frequency. So this reinsurance market is very important. One of the things I think that one ought to say about this, therefore, is that one of the mechanisms that are used, which I don't think you stressed enough, is oftentimes once the loss occurs, one party buys out the other from their position. And so what happens if you're a reinsurer and somebody else is a primary insurer, what the reinsurer will say is, look, I'm not as good at defending these cases as you are. There's a real conflict of interest in the defense when you have to deal with the settlement when the issues are partners, because essentially if I settle for a fixed sum, the primary guy is going to have to pay more and the reinsurance guy is going to have to pay with an upper level less. And so what I'm going to do is I'm going to pay you a fixed sum and then what you have to do it. So I think one of the mechanisms that you see is one where, in fact, you redefine the contract after the loss has occurred so as to avoid that conflict of interest. The second point that I would make in exactly this kind of situation is that the exact same situation arises in a slightly different way with respect to excess coverage as opposed to reinsurance coverage. And it's the same sort of conflict. The difference is when you're dealing with excess, there's no privity of contract between the primary insurer and the excess carrier, as there is with respect to the reinsurance. So that's a more naked kind of relationship. And the third type of situation that you have to worry about is renewals, which take place with regard to certain kinds of losses, in which everybody agrees in the good faith renewal, but they don't agree exactly in the right. So they'll give you an illustration. For many years, ending 36 years ago, I represented Fireman's Fund when it had all these huge respective losses associated with Agent Orange and with asbestos type cases, and they had renewal clauses. And what happened is you had all sorts of problems on how you did these things. What was interesting about it, nobody thought that since the clause was vague, you could plead vagueness. Nobody thought that what you can do if you had a renewal clause is to charge somebody the exact same amount that you would charge them if it was a new person coming on the block with any prior commitment. And yet somehow or other they managed to work these things out, to pick out these kinds of intermediate numbers. And they did so, I think, with a fair degree of aplomb. And so I think what this shows is you're there. These are not random arrangements, of course, however. These are all people who are steeped in the insurance industry. And lots of times these companies have worked one with another. They're also, you didn't mention this, but I think it's important, they're also members of trade associations of one kind or another, which require them to work together on common projects, which then helps with the familiarity element, which turns out to be important. And so it's there. Now, this problem also happens more generally. And let me just mention one very quick kind of an arrangement of the sorts of things that you have to worry about, or maybe a couple, depending on how much time. One of the things that you do is, for example, is how do you figure out what's to be used with standard essential patents when you want to create some kind of a common platform against which everything else can be used? And it turns out that these, again, exactly are the kind of self-enforcing kinds of contracts that you have to have, because judicial intervention comes too little and too late. and there are a set of institutional safeguards that are the same. So I've actually worked with some of these companies and so forth, and one of the interesting things that you discover is that there is the good faith obligation at the back end, as there always seems to be, which binds, but also the technical people who are in charge of the standards are not the marketing people who are in charge of profit and loss kinds of institutions. So what they do is they start to create various kinds of separations that are going on. Another illustration which gives rise to the same situation is the very complicated situations with respect to biologics under the BPCIA, in which it turns out that you have a kind of forced cooperation so that there's going to be a generic that's going to come in after somebody who started with the biologic. And one of the things you do there is exactly the same as in the other place. What you do, you have elaborate technical committees that result in the transmission of information, but they are quarantined from the rest of the company, because one of the problems that you have is exactly what Sadie pointed out to. You don't want a trade secret to go public with respect to it. So I think it's a very rich area, and I would urge you to keep going and to see how these other things interact. Now, with respect to the question of going on to the next paper here by Lorianne, this is a very different kind of stuff. And there are two ways to do this. And one of them, which is gaining in popularity, is the one that Lorianne does, which is sort of brute computational force to figure out the ways in which these various things are put together. I am not a particular fan of this method. I would say it at the outset. Generally speaking, when I do legal history, I think it's very important to read the sources and to read them closely. Sometimes when you see something which is cited without any kind of authority whatsoever, you could treat it as being reckless armchair historicism and so forth. But in other cases, it could be that the proposition is, in fact, particularly with older judges, not so much in the late 20th century, but in the 19th century, writing in a more essay tradition, we just simply state this proposition because everybody knows that it's true and it's that way. So, for example, in a case called Field against Clerk, you see a very broad declaration of that. There's a non-delegation doctrine which we apply in constitutional law, zero citation with respect to it. But nonetheless, I treat that as a fairly accurate statement of what the history is rather than law office history, because when you know all the other collateral sources that come from different places, different people, and different times, it seems to fit in with the general kind of structure. So then the second question is, when you're starting to look at sources, what counts as the relevant set of legal history sources? Much of what legal history does is to cite the references to the Constitutional Convention, and I think what Lorianne says is probably right. People like Krosky wanted to brand Madison as a hypocritical liar and worse, basically trying to upset everything, particularly on the Commerce Clause and various kinds of other subjects. I think later historiography showed that he was more of a paranoid rather than getting this stuff correct, and that Madison, for the most part, had pretty accurate notes, not perfect in every regard and so forth, but like everything else, they required some kind of interpretive gloss. But I think it's also important to recognize that when you're doing this kind of constitutional issue, there are two other things that really start to matter. One of them, it is mistaken, I think, when you do constitutional history, to think of this stuff as being simply a textualist debate. As I mentioned in connection with Katherine's paper on Section 1983, there are huge numbers of implied terms that are added on top. It's vicarious liability. The entire police power discussion in the United States Constitution is completely non-textual. No matter how much you read the word property or freedom and so forth, you can't come up with what the police power is. You have to know something about background normative laws. And in many cases, what you see is that the battle is about those kinds of illustrations rather than anything else. And you can start to see lots of times what the history is about is not the Constitution. It's, for example, if you take something like the oil states case, on which I wrote 3 kinds of papers, various stages of the argument. It's the argument of how do you transfer what we know about the English patent system into the American patent system. And it turns out that the English system had a very different set of institutions from the American one, much more discretion in the English system than in the American one. When Arnold Plant basically said patents don't have much to do with innovation, he was thinking English. It's not at all clear that those results would help if you use the American system and so forth. And so what I think what you have to do when you do this stuff is to be very aware about the ways in which legal history is being used, not to deal so much with the text, but with something else. And now, why is that the case? I think I have about 1 minute left, so I will try to do it. which is that when you start taking some of the great questions of American constitutional law and ask yourself what the legislative history is at the time of the founding, what you discover is on the Commerce Clause, nobody says anything about its application to domestic disputes. There is some discussion about the way in which it applies to foreign powers. But if you want to try to argue either for or against Wickett and Filburn, Gibbons and Ogden or whatever, there just isn't any history out there that can do it. And so what you then start to do is to look to much more global questions about if slavery is an important constituent, can you have uniform congressional jurisdiction over local affairs? If not, then how does that apply? And that gets you into the doctrine of unconstitutional conditions. Could you in 1840 have decided to say that any goods made in any firm that had slave labor could not be shipped in interstate commerce? That would have been the Civil War. The answer is no, but like why is not all that easy to understand. So I tend to be, when I'm doing these things, much more holistic, try to read the sources in greater detail and care, and to figure out which are and are not law office history. And lots of times it is law office history because it's just kind of sloppy work. But what you really need to know in many of these cases is a real understanding of the background social institutions of which the constitutional stuff turns out to be a part. I think that's true with 1983. I think it's true with unconstitutional conditions. I think it's true with the police power and lots of other stuff. And I think the effort to try and pin things down often gets great precision about issues which are not the paramount ones that we have to deal with. I think my time is up. I'm a good boy.
Absolutely. Thank you very much. And again, I will give 30 seconds and very much 30 seconds to each panelist if they'd like to respond. First to Professor Blanchard.
Thank you, Richard. I'll leave the time for questions.
Fair enough. Is Updike Toler?
Thanks. Just two quick responses. Richard, I agree with you wholeheartedly that this shouldn't just be a textualist inquiry, and that I think that's one subtext of this article is that this Constitutional Convention provides context to the text of the Constitution of why it was implemented, etc. And so I would probably disagree with many originalist theorists in that regard of its relevance because it provides this context, and I think it's important. Secondly, I also you actually make a really interesting point about how the convention doesn't have a lot of discussion about really important clauses. There's lots of reasons for this. Madison was sick. I think he was depressed during the latter half when it was legally relevant after the Committee of Detail. And you see something that I cut out about half this paper, but something you see the justices doing is checking in with the convention and saying, there's nothing there. We have to look somewhere else. So they're essentially doing what you've just talked about. And I think that there's something there as well that I'll probably write about later. So with that, I'll turn the time over to questions.
Great, thank you. And if folks in the audience have questions, feel free to raise your hands. I'll start with a question first, and this is to Lorianne Updike Toler. To what extent, for a paper on methodology, I have a methodological question. Is this really a paper about citation practices? In the sense that if you did a robustness check and ran your analysis on a standard university level history textbook, what would it say about its methodology?
So if I think I understand the question of is methodology about citations, or is it about more substance from a kind of standard? What would standard historical methodology say about citations? Is that correct? Okay.
Yes.
So one of the limitations of this paper is that as a quantitative paper, we had to quantify something. And so we veered away from kind of substantive conclusions about history. This is not about whether or not the history is good. It's about the methodology. And I think at base, most historians, and I did check with a few as I wrote this, would agree that methodology has to include, whatever else it does, it has to include recourse to the primary record and appropriate contextualization. And you can kind of extract that down to a finer level of kind of generality of, Are you citing? What's the number of sources you're citing to? What's the kind of sources that you're citing to? And do they overlap? So it's testable. It's not a perfect map onto what's good history, but if you limit it to methodology and then you kind of say, these are the base issues that you have with methodology, you can then test it, which is what we tried to do.
Is there a question from the audience which would take priority or anything I have to ask?
There is a question from Leotis.
Good. Lee?
There we go. Sorry, I was just unmuting. So this is actually for Lorianne, and I'm wondering about your category of cases. It strikes me that you might, I'm not sure if you need, if this is right, but it does seem to me that you can use cases a number of different ways. One of them could be, in blah, 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 we said so and so. Another way you could use them is the standard practice, the standard view of this particular language in this other court, that we're not citing ourselves for, in other words, seems to have been such and such. And those strike me as potentially different kinds of authorities, and at least the second kind of use of cases strikes me as something that makes a lot of sense when you're trying to understand a legal term. So I'm wondering if you have thoughts about that.
Yeah, I don't. If I understand your question, then it's there's two different ways to cite to another case. One is this is what this one says, and this is the kind of the standard kind of legal terminology and history provenance. And if that's correct, then I address this in the paper that, that's a legitimate use of another case as a secondary source. The point overall, of and especially in cases of constitutional first impression, you want to know not only what the first case to interpret this said, but also, as you say, what's the standard way, what's the historic way from these English cases. But if those are the majority of your secondary sources and you're not looking, I think that's appropriate. You've got to get the legal understanding, and especially if it's a second use as you're talking about. But if that's what you're using to the exclusion of historical context and you don't understand, and therefore you don't understand the historical context, I think that's where the problem lies. It's not necessarily that you're citing them, it's that you're not citing this other genre, the important genre, when you cite to primary sources, which is the historical understanding of them.
And in the waning minutes, a question from the audience, John Harrison.
Good.
I think I am now unmuted.
Yes.
Yes. Lorianne, again, a question for you, which is, in a quantitative study like this, is there a way to get at, and did you try to get at, cherry picking and one-sidedness? Because you can cite original sources, you can cite quality secondary sources, but if they're all on the same side, you're not really doing that good a job. And is there anything to do to measure quality in that sense?
There potentially could be, and that's a really important question. The only way that we got at it, potentially that's another paper that I'd like to try to think about how to get to that. The only way that we looked at it is whether or not the sources swayed them from their expected political outcomes. And so in that sense, if they were cherry picking, they're not going to be swayed because they've already had, so Justice Thomas, for instance, he actually was the best all around historical athlete, which isn't saying much because they were pretty poor overall. But as you saw from the regression analysis, he's not swayed at all. So you could say it's a kind of backdoor way of saying, well, he probably is cherry picking these sources to get to his predetermined outcome. He's not swayed in any sense. He always votes conservative.
He is not faint-hearted, is he? And
not faint-hearted.
He's not big on stare decisis, and he's not big on customary practice. And Scalia thought all of those things really mattered. I think he's more accurate in the way in which it does. And in fact, if you go through the Constitution, the number of cases which actually start out, well, we've been doing this from 1850 onwards, so it's constitutional. That's the Hoboken case in Murray's Lessee in Article 1 courts. It's the inheritance tax case. They do exactly the same kind of thing. And so we do have this other constitutional condition, which is long-term practices could either fill in the gaps or in some cases override a specific text. Look, I mean, there's no standing in the Constitution. That's not a requirement of Article 3 in the sense that Scalia puts it there. He just made it up. And, 100 years, not he, Frothingham and Miller, 100 years later, it's now a constitutional requirement. Are we done, or can I ask? I think we're done.
I'm afraid we're short on time. But thank you all very much. Thank you to the audience members for sharing your afternoon with us. Thank you to the panelists, and Happy New Year.
And